and thank you all for joining us on our third joint webinar with Maria Scotland, the joint head of the family law team at 5 St Andrews Hill. I'm Alison Green, head of the family and relationship team at Mackrell Solicitors. I'm joined today by my colleagues in the team, Jim Richards and Manisha Hurchin. Today's webinar will cover the area of law related to the relocation of children in England and Wales, the UK generally, and also overseas. We will therefore cover the issues that arise when a parent wants to move a child against the wishes of the other parent. When a parent wants to take the child abroad to live, they need the written permission of the other parent or a judge's approval for the planned move. However, until recently, if a parent wanted to move within England and Wales or the UK generally, not only did they not need the other parent's permission or a court order, but it was also very difficult to stop them moving. There had to be exceptional circumstances in the case. So, for example, the child not wanting to go and being of an age where they could vocalise their views, or else the child being disabled. So we're going to consider today in the webinar what the current law is, the wider implications of a child moving away from one area in the UK to another, and, for example, the impact of that on where they go to school, the payment of school fees, child maintenance payments, and also the impact on what happens with the time that the child spends with the parent left behind. We've allowed time at the end of the webinar for questions as ever, and also if you want to make direct contact with us, we will have our contact details on the screen at the end of the webinar. There'll also be a poll, and if you want a confidential chat with us, please do complete the poll and then we'll make contact with you. So Manisha, can you tell us who has the ability to take decisions in relation to where a child should live?
Yeah, thank you, Alison. When we consider that, the first thing we need to start with is the concept of parental responsibility, which we abbreviate to PR, and you might have heard that short term used quite a lot. Now, parental responsibility is the term we use to describe the rights and duties a parent has in respect of the care and upbringing of a child until they've grown up. In 2015, the president of the family division then, Sir James Munby, commented that parental responsibility involves duties owed by the parent not just to the court, but to the child. So that's interesting to note, but important to remember. So that's parental responsibility. How do you get that? If we could have the next slide, please. Now, birth mothers and married fathers share parental responsibility for their children from when they're born. With unmarried fathers, they acquire parental responsibility if they're named on the child's birth certificate or they've acquired parental responsibility with the mum's agreement or otherwise through order of the court. Now, the law is slightly different in Scotland when parental responsibility is acquired if the parents are married when the child is conceived rather than at the point of birth. And in Northern Ireland, where an unmarried father acquires parental responsibility for his children if he marries the father after birth. With same-sex partners, they'll both have parental responsibility if they were civil partners at the time of the relevant treatment involved. If they weren't, then the second parent will need to acquire parental responsibility through agreement. It might also be relevant to know that parents can acquire parental responsibility for their adopted children as well. So whilst we see that there are various ways to acquire it, I think what it demonstrates is that the principle of parental responsibility is very important. Once you've got this parental responsibility, what do you do with it and how can you use it? So in legalese, we call that exercise of parental responsibility. And what that means is when two parents share PR of a child, neither one of them can unilaterally make an important decision in the child's life without the agreement of the other parent. And this includes where their child is educated, so what school they go to, and whether the child emigrates with one of the parents to live abroad in another country. So the question for us to consider today is whether parental responsibility prevents one parent moving within the UK with their child without the consent of the other parent, and if not, what the other parent can do to try and stop that move from taking place.
Okay, Jim, so can you explain the position where a separated parent with a child wants to move from one location in England and Wales to another, be that close by or at a fair distance?
Indeed. Okay, so the starting point here is the Children Act. And it's interesting because the Children Act is almost silent on the question of internal relocation. So the law as it is one which has been developed over a period of time by judges. So if you start by looking at the Children Act, you'll see there's mention there of circumstances in which you can and can't take the child or children out of the jurisdiction, so foreign holidays or emigration, whatever it may be. But it's essentially silent on the subject of internal relocation. So that's something which over the last, 20, 30 years has developed. And as it's developed, it's changed. And the position that we had when the Children Act was first brought in is not the position that we have now. It's evolved. The current situation is one where judges will say, in effect, that a welfare test predominates, and any decision in terms of where a child should live has to be subject to the rigor of the welfare checklist. And that's fine and dandy in theory. However, in practice, what it means is that there can be different results in similar situations, shall we say. And this is something which is difficult when you're thinking about making plans, and you're thinking about what you can and can't do, and particularly if you're trying to advise someone on that. I have mixed experiences of this. I've had cases in which some courts have placed very rigorous restrictions on clients moving from, in one case, Kingston to Kent, because the circumstances of that case were such that the judge considered that the motivation was dubious. And so the essence of this is an analysis of the particular facts which apply in the particular circumstances. And what that gives rise to is a differing outcome, which is sometimes hard to reconcile. The situation we're now in is one where the courts have essentially abandoned the idea of exceptionality and said in terms that the test for relocation within the jurisdiction or without should be the same. So whether you're moving from, shall we say, Portsmouth to Newcastle, and you might say, why on earth would you do that? And I'd probably agree with you. Or whether you're moving from Portsmouth to Calais, the test is the same. And it's a focus fundamentally and predominantly on the welfare of the child. And if you want to do something which involves a change to the status quo, then it involves a welfare analysis, assuming that it's not agreed to. I mean, that's a key thing here. What we're talking about here are disputes. If you have agreement, then essentially you can do what you like. So the situation we're in here is non-consensual movements by parents within the country, within the United Kingdom. And in this context, the United Kingdom includes Scotland, Wales, Northern Ireland, but it doesn't include Guernsey and other little diddy bits. So it's it can give rise to some curious outcomes, shall we say, certainly historically, perhaps less so now with the refinement of the law. There should be a more homogenous approach, but quite how that plays out in any given case remains to be seen. And it's really vital, I think, to plan and to organize and to get your ducks lined up in a row before you do anything.
Okay, so are there special rules in terms of a move from England to Scotland or Northern Ireland?
Well, yes. I mean, they're subject to the welfare checklist. So essentially, it's the same if you're going to Northern Ireland or Edinburgh or wherever, as if you're going from London to Norwich or Portsmouth to Penzance. The analysis has to be one that it's in the child's best interests. And I think the key is the motivation and the impact on the child. Those are the things which seem to be uppermost in the judge's mind. If you're a parent who is in any sense perceived to be malign, and you're using that move to compromise the relationship between the child and the parent who remains, then your chances are lower than if, for example, it's a work-based move or something of that nature. So it's highly fact dependent. And the starting point, certainly with internal relocations, was always that you should be able to do that which is reasonable. And I think essentially the law has changed its language, but it boils down to that, because that which is reasonable is likely to be welfare compliant.
Okay, so to Scotland and Northern Ireland, it would be considered to be internal relocation. What about if you were looking to go to the Isle of Man or the Channel Islands? Is that internal or external?
External. So, I mean, bizarrely, it can involve a shorter move in terms of kilometers, but it can fall within the rigor of the Children Act. So that's important in the sense of, well, it's important in one sense. I guess it's important in a who's the applicant, who's the respondent sense. And we'll come on to cover that when we discuss the procedural steps you can take. But essentially, whether you're going externally or internally, if there is opposition, then the current state of the law is that it reverts to the welfare checklist. You have to demonstrate that the move is in the interest of the child, whether internal or external. It's just that, are you using a sword or are you using a shield? Maybe that's a way to look at it, applicant or respondent.
Okay, that's great. So Maria, obviously you've had some experience of this in terms of case law. Can you share some of the experiences with us?
Yes, certainly. And Jim's right, whilst the test of exceptionality has been removed and we still look to the welfare checklist in both internal or external relocation cases, it's still important to identify whether you are moving a child out of the jurisdiction or within the jurisdiction. And what we term internal relocation cases does include a move, as Jim said, to either Northern Ireland or else Scotland from England. One of the first cases to establish that a move to Northern Ireland was internal relocation as opposed to external, so out of the jurisdiction, was the case 2001 case of Riaf, children residence order. The facts of this case, in summary, were this involved two children who were 10 and 5 years old at the time of the court case. And the issue was where they would live and with which parent. The parents had been married, they were now divorced, acrimoniously so, and the children, perhaps unusually, were living with their father, who was their primary carer. The mother, unfortunately, was alcohol addicted, and both mother and father were living in Gloucester. The father applied for permission to move with the children back to Northern Ireland, where he was born and where he'd grown up as a young boy and young man. This was against the mother's agreement, and the judge at first instance prevented the father taking the children on the basis that such a move was identified as an external relocation. So that was a move out of the jurisdiction, out of England and Wales. But the Court of Appeal held that the findings of the lower court were wrong. And Mr. Justice Astle stated that the UK, without further definition or reservation, includes Northern Ireland. And Lord Justice Thorpe considered why a move within the UK should be permitted without the same restrictions as a move outside the UK. So that was the first case that identified internal relocation includes a move to Northern Ireland. Then we also look at the case of Reese, prohibitive steps order, which is a 2007 case. This was an appellate case where, again, the Court of Appeal reversed an order made by a judge after a trial at first instance, which had prevented a mother moving with her 2.5-year-old toddler from Huddersfield to Northern Ireland against the wishes of the child's father. The parents in that case had had a very short relationship and had never been married, but their son, who was only a toddler, had a close relationship with his father. The father was a Huddersfield man with close ties to the community and family in the local area. The mother, like the case in Reese, had hailed from Northern Ireland and wished to return there. The judge at trial originally prevented the mother moving, except for a holiday, but the Court of Appeal set aside this order, and Lord Justice Thorpe said the requirement for judicial sanction in the absence of parental consent is limited to removal from the UK, and thus a removal from England to Scotland or to Northern Ireland does not require the approval of the court. So these were the cases which established internal relocation includes Scotland or Northern Ireland, as Jim told you. And the reason for labouring that is because at first blush it seems unfair when you consider the distance and the travel involved, which can be as great as a move to France or Northern Spain. but a move to France or northern Spain would be seen as external relocation. And we'll come on to why the difference. Although you've got the same welfare checklist, you haven't got the security of Hague Convention. If there's a move without consent and you wish to either prevent that or to seek a return of children, an internal relocation, you cannot call upon Hague Convention for return, whereas an external relocation you can. So move to Northern Ireland or Scotland is one which is seen as internal relocation.
Great, thanks. Can we have the next slide, please? So Manisha, obviously at the moment, I'm sure that not that many parents are looking at moving overseas with everything that's going on, but can you explain the rules in relation to that if they decided they did want to proceed?
Yeah, of course. So where two parents share parental responsibility, as we've heard, the law prevents one parent permanently moving their child or children outside of the UK without the other's written agreement or by way of court order. And when we talk about the court making an order, it's the court granting permission where the other parent is not giving their consent. So if one parent does want to move abroad with their child to somewhere outside of the UK, then this move is called an external relocation. Now, normally, external relocation without the other parent's agreement in writing or court doesn't give permission is only permitted for a holiday or less than 1 month if there is a child arrangements order in place, giving the sort of resident parent the right to do that. Otherwise, this move could be deemed a child abduction. So parents have to be very, very careful if they're in this sort of situation and want to, move with their children abroad. And they must seek proper advice in plenty of time, as early as when the thought comes to your head, please take advice on it to avoid sorts of situations. One other thing I should say here is that consent of every person with parental responsibility is required, because there will always be some circumstances where it's not just the two biological parents that share parental responsibility for a child. So that's just another element to bear in mind. There could be a grandparent, there could be various other people that have PR for whatever reason. So in terms of how it all works, generally the same considerations apply for internal and external relocations, as we've already touched upon, and that's been tested and established by case law over the years as well. Now, obviously, with an external relocation, that does involve moving to a completely different country and a completely different jurisdiction. So further considerations are needed depending on the intended country of move. So, for example, the court would require really precise information on how health and education systems work, for example, if those systems are very different to ours here. And of course, exact details are going to be needed of how the child's relationship with the left behind parent will be promoted, given the distance between them and all of the potential, time zone considerations. So a working example is, moving away from London to Cardiff will have very different considerations to moving from London to New York, because again, you've got different healthcare systems, potentially different education systems, obviously the time zone differences. So, it is varied and it's very specific. But the overriding legal principle to be applied is that the welfare of the child is the paramount consideration, and that the focus should be on what is in the child's best interests. And that's a theme that runs through everything we're talking about today, because that really is the focus of these applications. Each case is unique to itself and will be decided on individual circumstances, of course, but the parent wishing to relocate needs to set out a very, very detailed plan with evidence wherever possible as to why the proposed relocation is best for the child and would provide a better life for them rather than here in this country. So it has to be a well-researched and well thought out plan, with the focus of all of that being on the child's best interests.
Okay, can we have the next slide, please? Maria, if one parent wants to stop the other from moving within the UK, so going back to the internal relocation situation, what can they actually do?
There are steps they can take. If a parent objects to their child being moved within the UK, and as we've seen, again, this includes all parts of England, Wales, Scotland, or Northern Ireland, they must make an application in the family court or they can make an application in the family court for one of three possible orders. So there's three potential applications that can be made. First is an application for a child arrangements order with a condition attached, which regulates where the child can or cannot live. Next is a specific issue order application, or else a prohibitive steps order application. Specific issue and prohibitive steps orders are actually injunctions which do not allow a parent who wants to move or take the child with them by placing restrictions on where a child can live or which school a child can attend. The court stops the parent who wants to move taking a child away from their current home using these types of orders, or requires that parent to move back with the child. The parent who objects to the move has to make the application on form C100 in the family court under section 8 or 11(7) of the Children Act. If there is a child arrangement order already in place, then the application would be for a condition to be attached to that child arrangements order. So it's a variation of the existing child arrangements order, which would specify then the location at which the child must reside, or more likely a stipulation as to which school the child must attend. However, imposing a condition of this nature is a power that the court exercises very sparingly, and only in exceptional circumstances, as we shall see. Alternatively, if a parent wishes to relocate and knows that their plan to internally relocate will be opposed by the other parent, they may apply for a specific issue order which permits them to relocate, and in appropriate circumstances, an order which allows them to change the child's school. So permission to remove a child from one school, permission to enroll them at another school. In circumstances where there are cross applications, so you've got one parent making an application for prohibitive steps order, preventing a move, another parent seeking an application for a specific issues application, allowing a move, then the only order which is going to regulate where the child actually lives, whether internal relocation is permitted or not, would be a child arrangements order. So a child arrangements order may be the order which actually settles where the child lives, which school it goes to. In general, prohibitive steps order is an order which stops a parent exercising their PR, so exercising their parental responsibility for their child without the consent of the court. It is a form of injunction to prevent something from happening. This can include an order that stops the parent being able to move the child from an address or a named school. Next slide, please. Thank you. The specific issues order is a different type of injunction. As opposed to preventing a parent from doing something, by contrast, it gives the parent the instructions or directions to do something specific, such as ordering the parent to return the child to an address or a school. The parent who objects to their child being moved internally, so internal relocation, can apply for a prohibitive steps order and or a specific issue order under section 8 of the Children Act. The applicant parent could, for instance, apply for a specific issue order for the return of a child from a certain place and a prohibitive steps order for the non-removal of that child thereafter, or alternatively, an order to prevent the child from being removed from its current school and a specific issue order, the child must attend a named school. The application can be made either in existing family proceedings, such as when applying for a child arrangements order, or it can be made as a freestanding application, or else it can be made on an urgent without notice basis in existing proceedings, or freestanding where there's a real urgency. The restrictions in respect of these types of applications are limited to the age of the child. So the prohibitive steps order specific issues applications can only be made in respect of a child who's not yet reached 16 years of age, except in exceptional circumstances, such as the child has special needs. The court will only grant an order if it does up to when the child reaches 16, and again, unless it's satisfied circumstances are exceptional. So if the child is coming up to 16 or slightly older, this might not be an application that you can make. And if the court does grant an order, that will only be until the child is 16 and not beyond unless there's exceptional circumstances. So those are the types of applications that can be made, and they're limited to those kinds of applications that can be made in circumstances where you wish to prevent internal relocation.
Thank you. So if we look at the next slide, please. Jim, what's the procedure for making these applications?
Okay, procedure. No eye rolling in the audience, please. So at MIAM, we start out with a mediation, information and assessment meeting, which is where a client is informed about the possibility of mediating, which I guess most solicitors would already have mentioned to their clients, and is a step in this situation, which is to go through possibly rather than with any sort of serious sense of resolving the claim. But who knows, mediation may sort these claims out, I don't know. And then the application form. So again, it depends on whether it's within existing proceedings or whether it's what Maria mentioned, a freestanding application. Again, it's a reasonably comprehensive form which sets out the details and the generality of why you're applying and what you're applying for and so forth. You send that to the court with a court fee, and I guess at the moment what we do is issue it online, and if it was within the postcode, the court would progress it that way. Obviously, if there's a degree of urgency, we're not going to wait for the court service to do their thing, because let's face it, that can take some time. Instead, what we can do is issue emergency applications, whether that be by telephone or whether that be through informing the courts, the relevant court, that something needs to be done quickly. So if you're in the sort of territory of prohibiting, in other words, someone is moving and you need to stop it quickly, we're not going to dance through the niceties of a MIAM. We're going to act quickly and have a hearing, probably by telephone, depending on whether it's out of hours or via Zooming or whatever the court service now use. So yeah, it's a procedural thing. Your solicitor will assist in completing that, and the court service will enable it to happen eventually. I don't know, what more can you say about procedure?
So what happens once you've made the application?
Essentially, you'll have a series of hearings. The courts won't make a final determination generally, particularly on an external relocation case at the first hearing. The court may well make an initial prohibited steps order if there's enough information contained in the application and any statement which you prepared to go along with the application, and then have a short return date, perhaps 7 days later or something like that. But if it's particularly in the case of planned relocations and you're the applicant who wants to move, whether it be within the country or externally, there's going to be a series of hearings. The initial hearing is going to set a timetable for the gathering of evidence. The second hearing is going to be, well, let's face the evidence and the information that's been filed. It may well be that CAFCAS have been brought in, or an independent social worker, as the case may be. And if things can't be resolved through discussions, then on we go to the traditional gladiatorial final hearing, at which it's all argued out with learned friends, and a judge makes a decision, and that's that.
Okay, so Manisha, we touched on the welfare test before, which obviously is what the court takes into consideration. Can you just elaborate on that a little bit for us?
Yeah, so the test that the court has to apply at final hearing is the welfare test. And as you say, we've all been talking about it because that is the focus, and that's what it's all about, the welfare of the child. But before the judge looks at that, what the judge has to do at final hearing is consider whether to grant the orders sought, by considering whether it would be better for the child to make the order rather than make no order at all. Now, this is called the no order principle, and the judge does have to remind him or herself of that as the starting point. More often than not, an order is needed in some way or the other. So then the child's welfare will be the court's paramount consideration. And the court has to have regard to what's called the welfare checklist, which is the statutory checklist under Section 1.3 of the Children Act 1989, if anyone wants to look that up. And specifically, this includes child's wishes and feelings. And it's interesting that that comes first. And then the court looks at the child's physical, emotional and educational needs. Then the court looks at the likely effect of any change in the child's circumstances. The court then goes on to look at the age, the sex, the background, and any characteristics which may be relevant in the individual circumstances. And then the court looks at any harm or likely harm the child has or is at risk of suffering. And then the court looks at the capacity of the parents and other carers of meeting the child's needs. So you can see that it's quite a holistic approach. There are a lot of considerations that a judge has to very carefully consider and apply all of these to the individual circumstances in coming to a decision.
So Maria, when we're looking at how that welfare test gets applied, presumably you've had some experience as to the decisions the courts have made.
Yes, there are a number of authorities which we tend to rely on, which are of assistance as to how the courts determine these internal relocation cases. So in other words, how they apply the welfare checklist. And a good starting point is the case of Reese. This was a case before Lord Justice Ryder, and assists us in how the court apply the welfare checklist to considerations for making prohibitive steps order. Lord Justice Ryder noted that a prohibitive steps order is a restriction on a parent's exercise of their PR for a child that can have profound consequences. And what he held was that once a prohibitive steps order is made, that parent loses the ability to exercise part of their responsibility and cannot regain it without the consent of the court. In other words, that they're prohibited from doing something by order of the court, and that prohibition cannot be overridden or varied by agreement with the other parent. So once made, it can't be relaxed. It has to be discharged. And so there is, according to Lord Justice Ryder, a high responsibility of the court not to impose such restrictions without good cause, and the reasons must be given. So there effectively is your test, that when the court is considering whether to prohibit somebody from removing a child from school, the appellate court have indicated that it's a high responsibility, it's a restriction which should not be imposed without good cause and reason. So we're looking for good cause and reason in our welfare checklist effectively. And additionally, consideration should be given to the duration of that prohibition. The courts held that the finite nature of the order must be expressed on the face of the order. So in other words, it's not open-ended. So when we're considering internal relocation, we're looking for good reasons to prohibit somebody from moving, or to, in case somebody looking to move, you're saying there's a good cause to move. Other cases which assist us with how the courts determine these include Riaf, another Court of Appeal case. This was decided in 2010. The parents were divorced and they had three sons and a daughter, so 4 children, various ages, but we've got eldest son who's 14, second child who's 13, middle child who's their only daughter was 11, and then the youngest child, their youngest son, was 9. Reason for giving you those ages, we've got a good spread of ages, but we've got 2 teenagers, we've got 1 starting secondary school, and we've got our youngest in primary school. This was a case where the second child, so the one that was 13, was mildly autistic and had other special needs. The family all lived in Middlesbrough. This was a case where mother, who was the children's primary carer, sought by application to move the children to the Scottish Orkneys, where she had come from. She had substantial connections with the region, and she had been offered a job there together with the new husband, so the children's stepfather. She applied for a specific issue order permitting her to internally relocate to Scotland. Now, what's interesting about this case is that the judge at first instance did not allow her application, so didn't allow her to move, and the Court of Appeal upheld that. Reasons why? Well, the children were all interviewed by CAFCAS, and the daughter, so that's the child who was 11 years old, expressed her enthusiasm for going. She wished to move, was looking forward to it. All 3 sons expressed a desire to stay in Middlesbrough. The second child, the one that was 13, and the child who had been identified as having special needs, stated that if everybody else went, so if his siblings went together with his mother and stepfather, he wanted to stay with his father. And when we look at the judgment of this, it's not what's set out is that mother's applications refused, Court of Appeal dismissed the mother's appeal. But I think it's of note in this case that the Court of Appeal highlighted the children's wishes and feelings, their ages, and the fact that the upheaval, such a big move on them, is likely to cause them emotional harm. So when we're looking for good cause, reason not to allow, in this case, the wishes and feelings of the children obviously were of magnetic importance, together with their age. The fact that they're of an appropriate age, they're teenagers, they can express their wishes and feelings and vocalise that. And it's likely that their ages were a compelling factor in this case. They're likely to have been felt to be children who would be able to vote with their feet, as it were, if the court made an order permitting mother to move. So that was a 2010 case. Then we've got Riaf, child domestic abuse, which is 2016. And the reason that this was an important case was that up until this point, internal and external relocation cases had tended to be treated differently by the courts, which was confusing. And this was a case which looked at the different treatment of external and internal relocation cases. The issue arose in the case of Riaf, where this was a case where the mother left the family home in Kent with the party's 1-year-old child and moved to northeast of England, where her family lived, without the father's prior knowledge or consent. Had she moved abroad, this would have been an international relocation case. Oh, sorry, I jumped ahead. Let me take you back. Reese, we've got 2015. This is probably the best case to start with before I move on to that case. Reese was a Court of Appeal case which involved a 10-year-old child. Lived in London with the mother. Mother wished to internally relocate to Cumbria. Parents had never been married, but the child had a good relationship with his father, and he spent 2 nights a week with him and every other weekend. So good and close relationship. Mother wanted to move to Cumbria, which would have had a significant impact on the time that he lived with his father. So father applied for prohibitive steps order. He wished the present arrangement to continue. Mother applied for a specific issue order permitting her to move. So this was the case, I apologise, where up until this case, the courts had approached internal and external relocation cases differently. And the Court of Appeal held that the separate treatment of the two types of cases was questionable. What they held was there should be no difference in the basic approach between external and internal relocation cases. A respondent in an internal relocation case does not have to establish exceptional circumstances to prevent an internal relocation case. And Lord Justice Thorpe considered the possible arguments for the different approaches that thus far had been taken by the courts in internal versus external relocation cases, and held there was no satisfactory reason for the difference. This was the case which established both cases should be treated the same and the welfare principle should apply. And that ultimately the decision hinges on the welfare of the child, wherever the child is being taken, whether outside of the jurisdiction or inside the jurisdiction. The child's best interest demanded this. We then move on to the 2016 case, because we've established through the Court of Appeal in the last case to the year before in Reese, it's the same treatment whether you're moving internally or externally with the child. This was the case where the mother had already moved internally by the time of court proceedings. She'd moved without the father's prior knowledge or consent with his 1-year-old son. And the father highlighted the case of Reese, which had been decided the year before, the fact that internal and external relocation cases should each be decided on the same basis, that being the welfare principle. And what he argued was that based on Reese, the court should take the same approach it does to as if the mother had moved the child abroad. And this should be seen as child abduction. The fact that the mother had moved from Kent to the northeast of England should not matter. If we're treating both these types of cases exactly the same, he said, then the court should take the approach that the mother had abducted the child. A case which set out that no, that they drew, and here the Court of Appeal drew a distinction between relocation and abduction, and held that the Hague Convention relating to child abduction had no application to mother's unilateral removal of a child to another part of England. So we pause there because the reality is these two types of cases are not the same, and we've seen that in case law. Although Reese was the one case in 2015 where thankfully we established that whether it's internal relocation we're looking at or external relocation, the welfare checklist is a paramount concern. That doesn't have to be exceptionality. What we now see is that if you are, that's all very well at final hearing stage and final determination stage, but if there is a move during proceedings or without father or else mother's prior consent and a unilateral removal, then a parent cannot fall upon the Hague Convention, cannot look to child abduction regulations and rules and statute if the move is internal. So there is clear difference, and it may be that most parents, in fact it would be that most parents would consider this unfair. So whilst we've got a general principle which applies to both types of cases, it's regrettable you can't look to child abduction protective measures if there is an internal relocation without consent. So this falls back to, it is absolutely vital if one parent suspects there is a planned move and they don't agree to that planned move, that they take steps to prevent that move. And we touched on that, the three types of applications that can be made. Because the reality is that by final hearing, if a move has taken place, by final hearing, and we know now that the time that it takes for a final hearing to be listed, then the status quo will have been established by final hearing and a child will be settled by final hearing. But there may be something we can do about that. You either can make your preemptive move. If you're left in a position where the move has taken place and it's too late, then what we should do is look to the child's age and see whether something can be done about the fact that a child has been moved from their school and whether that has effect on school fees, and something can be done by that to try and alter the status quo back.
Okay, so if we move on to the next slide then, what's the practical advice, Manisha, that you would give to anyone in this situation?
Yeah, so as Maria's already highlighted through specific details of cases, there can potentially be some ways or some elements that you can explore in detail to challenge a relocation. So in practice, the court will allow a parent to internally relocate if an application is made for permission or the parent objecting seeks in order to prevent them relocating, unless one or more of the following facts are present in that particular case. So as we've touched upon in some detail, the child might have expressed clear wishes and feelings that they don't want to go, or they're of sufficient age and emotional maturity that their wishes should be considered by the court. Now, you won't find in statute an age that's stipulated for this, so you can't say the child's 10, therefore the court must take into consideration. It's arbitrary and it depends on the child. Usually we're talking about secondary school age, so 11, 12 upwards. You know, a court would be minded to take into consideration what a child of that age is saying about the situation. And the court also has to look at, you know, are that child's wishes and feelings their own, or have their views been adversely affected or impacted by one parent's influence or alienation? So you need to explore that as well, because there could be a child that says, I don't want to go, but then when you delve deeper, all they're doing is sort of mirroring or mimicking what one parent has said, because sometimes children do get caught in the middle, as we know, and they will say what that particular person wants to hear at any given time. So it does require a more in-depth analysis. Also, you need to look at if the child is likely to suffer emotional or else physical harm if they internally relocate based on the facts of the situation. So even if your client or all of the parties or all of the experts haven't identified that, ask. There might be something there that just hasn't come to the forefront because nobody thinks it's relevant, but it can be very relevant. And then, as Maria said, the child's education can suffer, and they might be at an important stage in their education, such as final year or term of GCSEs and A-levels or equivalent, and coupled with any of the factors of that is a huge consideration. For if any of those elements are at play in a situation, do ensure you're dealing with it in detail and use any evidence that you can obtain to substantiate, what you're saying about this in terms of why that relocation shouldn't take place. Can we have the next slide, please? So if we look at school placement in a little more detail, a specific issue order can be used to determine questions about a child's upbringing, including the school that they attend. So where two parents share parental responsibility for their child, obviously, as we know, neither can either enroll or else remove that child from a school without consultation or the prior consent of the other parent. Now, if you look at this carefully, it's a good way to try and challenge and at least temporarily, if not permanently, prevent an internal relocation. If the child is of school age, since relocation to a different part of the UK will require a change of school, obviously. Now, also look at if that child is educated privately, because this could also then involve change of school fee payments or child maintenance provisions. So as I say, look at it carefully, because where everything else in the case might be on balance deemed as equal on the part of both parents, look at schooling, because it can be a useful way to challenge internal relocation and make the difference between stay or go.
Okay, so really what we're saying is that if there is a dispute between parents, you need to act quickly. And obviously, if you can negotiate and can resolve things between you, fantastic. Mediation is also a great option. It keeps the line of communications open, but you might want to have to act really quickly and use the court process. And obviously, if you do take advice at the earliest opportunity. As we've said, the court will look at the welfare test and make decisions on that basis, whether the relocation is internal or external. But it's always important to focus on what's best for your child. If what's best is for the child to stay, then obviously you need to try and encourage the other parent to stay, take advice as soon as you can, and try and work through it. But as I say, if you can't, then the court process is there to assist everybody. Unfortunately, clearly, these sorts of cases can have profound implications, because even with an internal relocation, there can be large distances that are put between the parents and thus the child. So for all of these reasons, do seek advice. As I said before, we're here and we can give you confidential advice. You can make contact with us. We're about to deal with some questions now. If you have got any questions, then do please feel free to put those in the Q&A box and we'll deal with them as we can. And once again, I'm going to mention the poll, which will be on screen shortly, so that if you do want to make, or us to make contact with you confidentially, we can do that. So looking at the questions which have come in, we've had a question saying, can you give an example of emotional harm and how that might be proven? Maria, is that something you can help us with?
Yes, so emotional harm is kind of a loose term for a child is not as settled and as stable and as happy as it used to be. So if we look back, I mean, the term was used, for instance, back in the case, where we had the 4 children whose mother wished to relocate with them, and the Court of Appeal felt that if the mother was permitted to relocate with the children, that was likely to cause them emotional harm. And by that, what the courts impliedly meant was, if you don't listen to a child's wishes and feelings, which are their own, and of a child who's of an age that where they can form, they can make their wishes and feelings are their own, and they're informed. So in other words, they know what it means to move. They know what it means to move from a school. They have cognizance about it. If you don't listen to that child, they're likely to feel injured, upset, act out, and that's likely to have long-term effect. Now, in that case, there was a CAFCAS report, or it might have been an independent social workers report, which expressed their wishes and feelings. So that was the evidence of what their feelings were, and emotional harm was likely to be caused if we ignored teenagers' wishes and feelings. But it's going to depend on the child. So emotional harm in a younger child might be that they're regressing slightly, they've gone back to bedwetting, they're acting out, they're angry or emotional, or else some children become regress. So emotional term is a loose term for which is a kind of overarching for the child is displaying upset and is no longer as stable and settled as it usually is, or this child is likely to be that. And it's going to be age dependent, it's going to be fact dependent. Evidence is going to include from both parents, but third party independent evidence would be from school teachers, nursery, might be if the child's seeing this, the school psychologist, they're talking to somebody, they've got seeing a therapist, or CAFCAS reports, independent social workers report. That would be your evidence. This is a child who's not being listened to, is unhappy, effectively. That's emotional harm.
Okay. And that's interesting because it does feed into another question that we've had, which is at what age do children have to be for the court to give weight to what they want to do?
I think Nisha touched on this. It's going to depend on the case.
It's
really depend on the case, but it tends to be that the court will take much more or place much more weight on a child's wishes and feelings as they are coming up to and into secondary school.
Yeah.
That said, they're not going to completely and utterly discount, but if you've got one child and that child's 4, what you'll find is a judge patronising the case and saying, I take on board that the 4-year-old has said, I want to live with daddy, I want to live with daddy. However, she's going to love it and she's going to be fine. And but if you've got a 4-year-old who's got siblings who are 12 and 14, they're all going to be conflated together. And who says, I don't want to go. Although you might have a judge saying they're likely to have picked up their wishes and feelings from their older siblings or else their parents. So it's really going to depend. But I think practice tends to be that, or my practice tends to indicate secondary school.
Yeah.
And even if you've got parental alienation, which does happen very often, you've got a teenager repeating verbatim, mum says, and sometimes even mum says that, you'll find that judges nonetheless may well do tend to take their wishes and feelings into consideration, because how do you reverse that child's wishes and feelings? Yes, they'll pick up on the fact that they've been alienated. They're likely to pick up their one parent's adverse feelings about the other and their deep desire to move, but they'll nonetheless take that wishes and feelings and place that in its in the weighing scales, and tend to tip the weighing scales, because the child's going to be damaged if you ignore them. So it depends. It's fact dependent, but I'd say secondary school and onwards, unless you've got a particularly precocious child who's much younger.
Okay.
I'll just come in with one point. One thing we haven't touched on here is sibling groups, and I think when you're dealing with multiple children and you have older children who are very much able to be articulate and express views to CAFCAS, there's also another consideration, which is that courts are very slow to split sibling groups because of the bond between children. And so if you have a highly articulate 14-year-old, a less articulate 10-year-old, and an 8-year-old and a 6-year-old, essentially the 8-year-old and the 6-year-old are going to slipstream the older children, because a court will recognize that the harm to an individual child can be magnified by splitting a sibling group. And so different considerations arise in relation to single children than perhaps do in relation to groups of children. So that's something worth bearing in mind. And if it's not covered by, for example, a CAFCAS report or an ISW report, then it's an important thing to adduce at a final hearing.
Okay, so Jim, just on a practical note, someone's asked, what if I don't agree with the judge's decision? Can I appeal?
Yeah, absolutely. I mean, that's the thing about judges and decisions. Yes, you can. But you obviously there's a distinction between I don't like the decision, I think the judge is an idiot, and having a basis to actually mount an appeal. So if a decision doesn't go in your way, and the unfortunate thing in these cases is they're very much binary. So it's win-lose, generally speaking. There's no middle ground here. One parent will be unhappy with the decision, but that does not in and of itself mean that it follows that unhappiness and dysfunction is capable of filling any kind of criteria which a lawyer would assess as being worthwhile and sufficient to pursue an appeal. In fact, you're going to, at some stage, to have to convince someone, a judge, that this is something that you need to, that is justified. So, you'll either have to get permission to appeal from the first instance tribunal or seek it later, if that's the way you go about it. And that requires sifting the wheat from the chaff, the emotional from the legal. But clearly, if a judge has exercised his or her discretion in a way which is inappropriate, then that's something which can be tackled. But certainly, one of the issues with this area is that although we've spoken a lot today about case law, you shouldn't interpret the case law as being a rigid thing. It's a guide. It's no more than that. And the exercise of the judicial discretion in terms of the welfare checklist is one that is it's discretionary by definition, and that kind of makes it difficult to appeal and very difficult to advise. I mean, sometimes more often than not, it's just it's not going to happen. But frankly, I think it's something to think very, very carefully about, even though it's high stakes. And certainly before you pursue any kind of appeal, you should reflect very carefully, and you should speak to the trial counsel and at a bare minimum have a conference to see where you go on it.
Okay, I'm mindful of the time. I think we've got time for one more question. Manisha, maybe you can help with this. What is a joint lives with order, and what are the benefits of it?
So a joint lives with order, we're talking about a child arrangements order here, and obviously lives with says, does what it says on the tin. It's an order that grants, that parent, both the parents, the right for the children to live with them. So a joint one means that they basically have a shared care arrangement. It might be on an equal basis in terms of time. It might not, but it still falls under, the catch-all term of a joint lives with order. The benefit of that in terms of what we're talking on today is that it gives the parent the ability to remove, the family's child or children abroad for up to a period of 28 days without the consent of the other parent. So typically where just one parent has a lives with order, it gives them the advantage of doing that. But where there's a joint lives order, it enables both of the parents to do that, or it arms both of the parents with the entitlement to do that.
Please feel free to drop us an email or give us a call, and we'll endeavour to help you. So thank you everyone for joining us today. Thanks to all the panellists for